All right, now we're going to get started. It is March 10th, 2022 at 9:08 a.m. And this is a regularly scheduled meeting of the Oil Conservation Commission. I'm Adrienne Sandoval, Chair of the Oil Conservation Commission and Head of the Oil Conservation Division. Will the other two commissioners please introduce yourselves for the record?
Thank you, Madam Chair. Good morning, everyone. My name is Greg Bloom. I am the designee of the Commissioner of Public Lands. Thank you.
Good morning, Madam Chair. I am Dr. William Ampuma, designee of Energy Secretary and also a professor at New Mexico Tech.
Thank you. Also with us today is Chris Moyander, Counsel of the Commission, and Florine Davidson, Clerk of the Commission. First item is approval of the agenda. Commissioners, Commissioners, is there a motion to approve and adopt the agenda for today?
I move to adopt the agenda for today.
Sorry, but I'm not getting Mr. Bloom except every second word.
I so move. Thank you.
Is there a second?
I second.
Okay. Mr. Moyander, would you do a roll call vote, please?
Madam Chair, Commissioner Ampoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair,
Approve.
the motion carries.
Thank you. Next item on the agenda is approval of the February 22nd, 2022 meeting minutes. Is there a motion to adopt those meeting minutes?
Madam Chair, I so move.
Is there a second?
I second.
All right. Would you do a roll call vote, please, Mr. Moyander? Will you do a roll call vote, Mr. Moyander?
Yes. Was there a breakup on my audio?
You spun for a second.
Oh, good. Commissioner Ampoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair,
Approved.
the motion carries.
Thank you. All right, next item on the agenda is adoption of the final order in case number 21324. De novo case number 21902. Application of Tom Ragsdale to revoke orders number R-20924 and R-20924A. Commissioners, have you reviewed the final order? And is there a motion to approve the final order in this matter?
Madam Chair, I have read the final order and I would make a motion to approve the order.
Is there a second?
Madam Chair, I do second.
Thank you. Mr. Moyander, would you do a roll call vote, please?
Yes, Madam Chair. Commissioner Ampoma.
Approved.
Commissioner Bloom.
Approve.
Madam Chair,
Approved.
motion carries.
Thank you. Commissioners, I believe you'll be getting a final order from the commission clerk, Ms. Davidson, today. If you could please sign that and send that back once you get that. If you, thank you. All right. Moving on to agenda item number 5, which is a continuance of the evidentiary hearing on invalidation of the division order. It was case number, de novo case number 21744. It was application by Cimarex Energy for a de novo hearing of case number 21629. We started this evidentiary hearing on February 22nd and continued it to today. Great, Mr. Savage, can we hear you?
Yes, good morning, Madam Chair.
Morning. And Mr. Padilla, can we hear you?
Yes, I'm here.
Okay. All right. Let's make sure that well, when we get there, I can move over any people who need to be made panelists. But first, I want to address the motions that were filed initially by Mr. Savage and Cimarex, and then a response made by Mr. Padilla, an additional reply by Mr. Savage. You know, we received those and reviewed those. But at this point, I would like to deal with that motion after we close the evidentiary hearing portion of this. So I would like to go ahead and continue the evidentiary hearing piece of this. And then we can discuss that, and I will give each of you an opportunity to briefly present on it at that time. So received, but let's get through the evidentiary part and then we can address it. All right, any initial statements, Mr. Savage and Padilla, before we continue with Mr. Padilla's witnesses?
Madam Chair, Raleigh Morris, Mr. Raleigh Morris is present. I just wanted to point that out. Mr. John Kaufman, who was one of our witnesses, he's available and he's present. He is traveling. He had a commitment to a trip that he had made, and he is traveling, and he will be available, but we may need to give him just a text or a quick heads up if the commission decides to recall him for further questioning.
Okay. Thank you. Anything before we get started back up with your witness, Mr. Padilla?
No, Madam Chairman. I think I had finished with Mr. Hedrick and had tendered him for cross-examination. I think that's where we were when we recessed.
Okay. All right. I think so. We'll go ahead and recall your witness, Mr. Padilla. I think we were just finishing up with your questions. So if you have any additional questions, I'll give you that opportunity, and then I'll go ahead and move to Mr. Savage for any cross and then commissioner questions. All right. Can you remind me how to state your witness's name so that I can state it correctly?
Hedrick. Maybe it's better if he identified or told us how to pronounce his name.
Attic. The J is silent.
Attic?
Yes.
Okay. All right. I believe you were already sworn in previously. Mr. Moiner, just clarification, does that still applies here, correct?
Yes, Madam Chair, because the hearing was continued and all the sort of rules still enforcement in fact for the hearing overall, Mr. Haddock is still under oath.
Okay. So just a reminder, you are still under oath, Mr. Haddock. All right, go ahead, Mr. Padilla. You can continue with any remaining questions that you have.
I don't have any remaining questions, Madam Chairman. I think if I have anything, I'll do it on redirect.
Okay. All right, then, Mr. Savage, you're up.
Thank you, Madam Chair. Mr. Haddock, good morning. Haddock, good morning. Thank you again for your testimony today, this second part of the hearing. As I mentioned last time, if you do not understand a question or feel like you didn't hear it correctly, please ask me to repeat it. We do not want you to answer a question that you did not hear accurately or misunderstood. Mr. Haddock, do you have copies of Cimarex's exhibits and Colgate's exhibits in front of you at this time? They are attached to the pre-hearing statements that were submitted. Mr. Haddock? I'm sorry, did
I'll have to pull them up.
we will be looking at Cimarex's exhibit C, H, and E today. Do you have those available?
Did you say E is in Edward?
E is in Edward, that's correct. C is in Charlie, H is in Hat, E is in Edward. Mr. Haddock, are those available to you?
Yes.
Okay. And also, we'll be looking at Colgate's Exhibit 3, specifically paragraph 8. Do you have that? Okay, I'm going to assume that you do.
Yeah, I was going to ask, I don't mean
Can
to
you,
interject.
All right, Mr. Haddock, when you are addressed, can you please respond either a yes, no, I'm looking for it, etc., so that we know that you can hear us?
Okay.
Thank you. Mr. Moiner, did you have anything to say? Sorry.
No, Madam Chair, I just wanted to make sure we've got a decent, we got a connection here, and I appreciate you outlining the need for the verbal responses. That's very helpful for Ms. McFarland as well to make a good record.
I have all that pulled up.
Okay, thank you. Mr. Haddock, I believe we left off with the question about Division Rule 1915-4, 12A, B6. This is the rule that requires the applicant to show evidence of attempts the applicant made to gain voluntary agreement, including but not limited to copies of relevant correspondence. Do you agree with that?
I'm not sure what the question is.
That we left off there, that we left off at that point.
Sure. I don't have the transcript available.
You said in your
I'm
previous.
sorry, Mr. Haddock. I'm really sorry.
Ms. McFarland, you just went mute. Muted. Did we lose Ms. McFarland?
I think we may have, Madam Chair.
No, I don't think so. I'm here.
Oh, there you are. Okay, you were muted for a bit. You got cut off. You said sorry, something, and then we couldn't hear anything else.
I said, I'm sorry, I'm not trying to be obnoxious, but I have to get a record, and certain people's voices are more difficult than others. And if they don't really make an extra effort, I'm sorry, Mr. Haddock, you're one of them, that it's hard for me. Thank you.
I'll try to speak loudly.
Mr. Haddock, you said in your previous answers that you are generally familiar with the pooling process, filing for proceedings to hearing pursuant to the rules of the OCD. The rule I mentioned is stated in the Colgate's Exhibit 3, paragraph 8. Have you had a chance to look at that? Have you had a chance to look at this rule that I referenced?
Okay.
Are you and you're familiar with this particular rule? Is that correct?
Yes.
Okay. Now let's look at your email exchange with Cimarex. That would be Cimarex's Exhibit C. Do you have that?
Yes.
Your email response consists of only 2 sentences. Is that correct?
Yes.
The first sentence is an attempt. The first sentence is not an attempt to gain voluntary agreement. It's basically descriptive. Do you agree? Basically describes the offset acreage in the.
Well, he asked me a question that was out of scope of the proposal, so I responded in a manner that.
But it's not an attempt. The first question is not. The first sentence does not represent an attempt to gain voluntary agreement. Would you agree with that?
No, I'm answering his question as to what's going on.
Is the first sentence?
Correct. I'm answering his question.
Is it a voluntary attempt to gain agreement, or is it not?
I would say it's part of the process of attempting to gain voluntary agreement because you're explaining what you're doing.
Can you read that sentence to me, please?
Our operated strip is in the north half, which abuts to other additional operated units due north.
So it's basically descriptive in nature. Would you
I already
agree?
told you that. Yes, I told you that it was descriptive and describing what we were looking to do and work out here.
All right, thank you.
Okay, like, there doesn't need to be any attitude. He's asking questions at this point that are appropriate. Please respond professionally.
Okay.
This is part of an evidentiary hearing. All right, go ahead, Mr. Savage.
Thank you, Madam Chair. The second sentence in your response ends with, quote, "We would be happy to talk some options for the offsetting acreage in order to fully maximize the development of the area." Is that correct?
Yes.
And would you describe the second sentence as a statement that you were open to discussion? Is that fair?
Correct. I put the discussion back in their camp to figure out what they were wanting to do.
It's basically that you were open to discussion. You expressed that in this second sentence. And more specifically, the discussion with Cimarex, based on your email, would be a discussion about the offsetting acreage, not a discussion about the uncommitted acreage in the unit you wanted to pull. Would you agree? Based specifically on the expression of that second sentence. Would you agree with that?
I would say that I was answering Mr. Kaufman's questions.
And you were expressing that you're opening to discuss the offset acreage. Is that correct?
Correct, because he was bringing up discussions about acreage that we didn't have an interest in.
Yeah, thank you. I agree with that. So is there any attempt in your second sentence to ask or request Cimarex to enter an agreement for the north half unit to be pooled?
It does not appear that way.
In your response, could you have responded, for example, by writing, "We would be happy to talk some options for the offsetting acreage in order to fully maximize the development of the area. And I would like to start talking about a JLA for your uncommitted 25% working interest in the north half. I mean, that would have been a possibility.
Probably, a million different ways you could answer that. You could reword that.
I agree. But if
I'm
you
not gonna let
if you had responded in that manner, do you agree that that would have satisfied an attempt to negotiate an agreement?
No, because I was answering his questions that he asked.
Hypothetically speaking, if you had said, "I would like to start talking about a JLA for your uncommitted 25% working interest in the north half," would that have satisfied an attempt under the rule to negotiate an agreement?
I don't know how I can answer hypotheticals.
I'll move on, Madam Chair. You said in your testimony, negotiations are a two-way street. and that you didn't know from the email what Cimarex needed. Is that correct?
I think what I was intending to state there is that they are a two-way street, and that I had responded and not knowing exactly what they needed, and I thought I answered his questions.
Right.
Said
You did.
I would have needed an additional response from them to.
Mr. Savage, you're interrupting the witness
I
continually.
did. I'm sorry. I realize that. Thank you.
Get that little last part of your response, Mr. Haddock. It finished with, he knows exactly, we know what we needed, and I thought I answered his questions, and then you said something else.
I would have needed further response from Mr. Kaufman to figure out what they were wanting to do in the area.
And you did say in your testimony that you didn't know what they needed. Correct.
No, it was in their camp to respond, correct?
Right. Could you have asked what they needed to reach an agreement in your email?
I think this is the hypotheticals again.
It's a hypothetical.
I just, like I said earlier, I mean, I would need better explanation on how to, we want me to answer hypotheticals, because there's a million hypotheticals we could go down.
It's a simple question. Could you have asked what they needed to reach an agreement?
Yes, I could ask any number of things, correct?
Yes. And if you had, even that would have been at least one attempt to negotiate an agreement, correct?
If I had asked her hypothetical, that would be one way you could agree that is a mechanism of asking for an agreement.
But you did not ask any question that could qualify as an attempt to gain voluntary agreement in those two sentences. Would you agree with that?
No, I would agree. I believe that I had asked what they were wanting to do with their acreage in the area.
Mr. Haddock, are you familiar with figures of speech, such as metaphors, euphemisms, hyperbole, personification?
Possibly. Which one you're asking about?
Excuse me, go ahead, please.
I said, in theory, yes.
When you say negotiations are a two-way street, do you agree that that is a metaphor used to describe your position?
Objection, that is totally speculative in terms of the question. For God's sake, you can answer that any which way in terms of figures of speech and that kind of thing.
Madam Chair, I believe that. Go ahead. Excuse me. I'm sorry.
Go ahead, and then I will
Okay.
make my decision.
Madam Chair, I believe it is true that there's only one way to answer that question. It is a metaphor. It is a metaphor that Colgate has brought up numerous times, and they have used it to support their position. And they have also brought up another important metaphor, and that is Mr. Padilla has repeatedly said, drop the ball. They're using these broad metaphors to address their obligations under very specific legal criteria. And I would like an opportunity to explore the applicability of these metaphors and provide a more precise and accurate metaphor during my questioning.
And the more precise and accurate metaphor would be?
Since the Colgate brought up the metaphor of dropping the ball, I would like to compare the obligations under Rule 1915-412A B6 to the metaphor of a tennis game, involving serving and volleying a tennis ball, as illustrating what's required under this rule and what's required in negotiations.
Okay. I think Mr. Padilla's objection is sustained. Mr. Savage, like, let's try to keep this as straightforward and simple as possible, without going down rabbit holes. Like, if you want to ask questions about going back and forth, in terms of negotiations, feel free, but I don't think we need to go down a metaphorical rabbit hole.
All right, thank you, Madam Chair. Mr. Haddock, would you agree that negotiations is similar to a game of tennis where parties volley back and forth, seeking some advantage on their side?
Sure.
So looking at Rule 1915 412A B6, do you have that in front of you?
I don't.
Okay, it's in your exhibit. It's in your exhibit 3, paragraph 8, if you want to look at it. Looking at this rule, do you agree that under the rule, Colgate is the party required to serve the ball, that is, make attempts to gain voluntary agreement that starts the volley of negotiations?
Correct.
I'm sorry.
Yes.
Okay. So the one and only email exchange occurring more than 4 months before the hearing, did Colgate make a good faith effort of serving the ball into Cimarec's court?
Felt that I had sent the ball back into their court with my correspondence, and that if they had any objections or concerns with our development plan, then they, you know, it was in their court to come back to me. And
Okay, so let's look at those emails. Who initiated those emails, Colgate or Cimarex?
well, the communication was initiated with the initial well proposal, and then
In terms of those emails, specifically those emails,
I don't really know what you're asking or going for.
did Colgate send the first email or did Cimarex send the first email?
We sent the first correspondence with the well proposal, and then Cimarex sent the first email.
Cimarex sent the first email. So your response, that was part of the volley of correspondence. It was not an attempt of a good faith effort to reach an agreement, correct? It was a response. It was not a serve of the ball.
Serve of the ball is in the well proposal. I'm not sure what's your question.
Mr. Savage,
I will move on.
reminder on the metaphor.
I'm sorry, Madam Chair. Can you say that again?
We decided no metaphors here. Like, let's keep it simple, straightforward, no tennis.
Madam Chair, if they are, Colgate is using metaphors. They're using metaphors of drop the ball and two-way street, and I don't think those metaphors are applicable. I really need to be able to address their metaphors with an understanding of what the rules really mean under an appropriate metaphor.
If I may, Madam Chairman, this is a ridiculous argument. I mean, when I use the term drop the ball, that was in a pre-hearing statement, essentially saying that it was an omission. I suppose I could have used the word omission rather than drop the ball, but I agree with your rulings on metaphors. This is ridiculous.
Madam Chair, if I could just maintain some reference to the metaphor, but keep it at a minimum so it does not become overwhelming in the questions.
Can you not just reframe your questions so they're straightforward, please?
I will reframe my questions and I will try to maintain a more straightforward approach without a full indulgence of the metaphor.
Okay.
Okay. Mr. Haddock, let's talk about the well proposal. Are you familiar with the compulsory pooling checklist that the OCD requires applicants to submit?
Yes.
In this checklist under joinder, the OCD requires a sample copy of the proposal letter. Do you agree?
Yes.
And the OCD also requires, as a separate item, a chronology of contacts, that is, communications with non-joinder working interests. Do you agree with that? And in fact, in your exhibits, you call this your communication timeline, correct?
Correct.
The events leading up to a hearing involve some form of interactions with the uncommitted working interest owners. Do you agree?
Yes.
Basically, pooling is a game that starts with a well proposal and leads to the hearing, correct?
Yes. I don't call it a game. Sure.
Colgate made a first attempt with sending with Cimarex sending it the well proposal. Agreed. But this wasn't really voluntary, was it? I mean, a copy of the well proposal is something you have to show to get through the pooling process, correct?
It's the very initial part of the process.
Very
Correct.
initial part, it's a requirement. Yes. So this would be the well proposal would be more of a mandatory requirement rather than an act of good faith negotiations. Would that be fair to say?
That's an. I don't know how to respond to that. I think it's over generalized. I don't agree with your statement. No.
It's something that's required to be sent to initiate the process, but in terms of voluntary good faith negotiations, it really is kind of sets the parameters, but not part of that process. Would that be fair to say?
No, I don't agree with your statement.
Okay. I'll move on. You acknowledge that Colgate's well proposal did not include a JOA for Cimarex to review. Is that correct?
Correct.
Would you agree that including the JOA would have helped to initiate and facilitate negotiations? Do you agree with that?
I think you keep answering my questions for me. The answer is no. I mean, we asked as part of our normal negotiations process, we provide the JOA upon request, or if someone wants to divest, then we'd have sales discussions over price and agreement in terms of agreement.
Mr. Padilla asked if you heard during his direct, Mr. Padilla asked if you heard Mr. Morris's testimony that Cimarex always sends out a JOA with its well proposal. Is that correct? That you heard that?
Yes, I heard that.
And you stated in your testimony that there was a period in the past when Colgate did not send out JOAs with their well proposal. Is that correct?
Yes.
And this would be the recent past and includes the well proposal to Cimarex, obviously. Agreed?
This was almost 3 years ago, but 2 years ago.
And you stated that now you are making it a common practice to send out JOAs with your well proposal. Is that correct? That is what you stated in your direct.
When possible. I mean, it's not a mandatory requirement. So if we are able to get JOAs out in the initial mailing, then sure, it simplifies the discussion process.
Didn't you say that it's becoming a more common practice for you?
Yes, that's what I just said.
Okay. Did your new practice, this new practice, the change in your practice of including a JOA with the well proposal arise from your acquiring a better understanding of the OCD rules and the risks of not abiding by them?
No, I would not agree with that statement. It is a administrative simplification. If my team is able to work up these, documents like JOAs and COM agreements in advance of well proposals, it just makes everyone's job easier and more streamlined. But I receive proposals regularly from operators in New Mexico, Uden, EOG, the list can go on, that do not include JOAs.
Thank you, Mr. Haddock. I'm going to ask about 4 questions to clarify the steps you used in your negotiations with Cimarex. Mr. Haddock, would this be an accurate description of your negotiations? First, you sent out the well proposal, correct? After that, you had one email exchange with Cimarex in August 2020 that Cimarex, not Colgate, initiated, correct?
Correct.
Your sole 2-sentence email response to Cimarex did not include an attempt to gain voluntary agreement for that unit, but did show you were open to discussions regarding offset acreage, correct?
I would not agree with your full assessment there.
Can you qualify it then?
I answered his question regarding a fact statement and then put the ball back into their court, if you want to keep using the metaphors. Sorry, I didn't mean to say the metaphor.
I like that metaphor personally, but I will try to refrain from using it. In the months leading up to the hearing, I'm sorry. In the months leading up to the hearing, about 4 months, excluding the well proposal, you never initiated communication with Cimarex in an attempt to gain a voluntary agreement. You agree with that?
Did not communicate with them after that email. Correct. You stated in your testimony that, quote, it's not uncommon for working interest owners to go radio silent on you until hearing notices go out, and then at that point they do realize that you're serious. Is that correct? Correct. That was in response to Mr. Cimarex's statements that they didn't believe we were a serious operator.
But you said it's not uncommon for working interest owners to go radio silent on you until hearing notices go out, and then at that point they do realize that you're serious. Correct? Before that, based on your statement, they probably don't think you're serious based on that statement, correct?
I'll try to answer the best I think where you're going with this. I mean, there are frequently parties that don't wish to sell or don't wish to sign a JOA until the hearing has been filed for, because they don't want to commit to something that is subject to change, because as we all know here, that the time between proposal and actual order can vary wildly in what happens with the parties. Trades happen, et cetera. And oftentimes, filing for the hearing notice, filing for hearing shakes those stalemates loose and gets the conversations going, because everyone then knows that there is a real situation to be addressed.
Yeah. If you don't mind, if I could read the full exchange in the direct. Mr. Padilla said, well, Cimarex is saying that burden that burden, saying that burden was on you to follow up, what do you have to say to that argument? And Mr. Haddock, you said, I would say, well, I answered their question, and if they had further questions, I never received those. And then you said, it's not uncommon for the working interest owners to go radio silent on you until hearing notices go out. And then at that point, they do realize that the applicant, is serious. Do you agree with that? That was in the direct and is your statement?
I don't have the transcript in front of me, but if that is what the transcript states, then I will agree that that's correct.
So before a notice is received, it seems apparent that a lot of working interest owners wouldn't have taken your well proposal seriously, same as Cimarex, especially since it didn't include a JOA. Is that fair to say based on your specific statement?
No, I would disagree.
Mr. Morris, in his testimony, said because Colgate's well proposal didn't include a JOA, and because Colgate did not reach out to Cimarex with any attempts to gain voluntary agreement, that Cimarex did not take the proposal seriously and gave it a lower priority ranking as a result. Is that what you remember of Mr. Morris's testimony?
I believe so.
Therefore, based on your own statement and your experience, isn't Cimarex's practice of how it assesses the seriousness of the well proposal not uncommon in the industry based on your statement?
I would actually disagree. I think that Cimarex is the only company I've ever heard of that has a ranking system whereby they throw proposals at the bottom of the list and don't review them or don't follow up.
Well, Mr. Haddock, if you said that it's not uncommon for working interest owners to go radio silent on you until hearing notices go out, isn't that implicitly a ranking system that they push the well proposal received aside and give it a lower priority and then give it a higher priority once the hearing notices are received? Would you agree with that?
I'm not privy to every working interest owner's individual evaluation process, so I can't answer that.
Mr. Padilla, and you point out that Colgate sent timely notice for hearing, and it was the fault of Cimarex to have not received notice. Is that correct? But Cimarex never said that Colgate's notice wasn't timely. Do you recognize that?
Sure.
Do you also recognize that Cimarex received the notice on Christmas Eve under very chaotic working conditions when staff were mandated to work from home in lockdown conditions in the midst of a COVID pandemic?
I think Mr. Morris's statement, some earlier filings, was that it was received and that there was images sent via email. I'm not really, I think we also established earlier that there were no COVID protocols. I mean, I have no control over when the OCD sets their hearing dates, and they have had one at the first week of January since as long as I can recall, and you have 2 months of holiday season there. I have no control over when those dates are set. That is completely in the hands of the OCD.
And I believe Cimarex agrees with that was not your fault. But do you recognize that there was a COVID pandemic going on, that companies were in lockdown, and it was a chaotic situation amplified by the Christmas season?
I'm not going to agree with discussing it. I mean, I don't know Cimrex's internal protocols. As far as we were aware, the OCD was operating as normally, just virtually. I'm not really sure what you're asking.
Okay. That's fair enough. I'll move on. Although not excusable, and the commission did not find Cimarex's excuse valid, is it at least understandable how Cimarex missed the notice letter during this time?
Sure, accidents happen. I think if I had shoes on the other foot, I would have the same. There would be implications against us as well if we missed something. I mean,
Thank you, Mr. Haddock. Let's talk about Mr. McDonald. Are you familiar with his testimony? Didn't you say in your testimony that unlike Cimarex, a person like Mr. McDonald, and I quote from the testimony, from your testimony, needs much more follow-up communication to perpetuate the rights? Somebody like Mr. McDonald, who is inexperienced, needs much more follow-up communication to perpetuate their rights. Do you agree with that? You said that statement?
correct.
Now, in your communication timeline, do you have that in front of you? Cimarex's Exhibit H.
Okay.
You state that you had various email exchanges with J.M. Wellborn Trust from July 2020 through January 2021. Is that correct?
Yes.
And that's over 6 months, correct?
Yes.
In fact, based on Mr. McDonald's testimony, he sent you 2 emails in July 2020 to which you did not respond. Is that correct?
Sure, I did not respond in July, but we were, initiated and came to an agreement in January.
So a whole month. So the whole month that you had listed as having email exchanges with Mr. McDonald, you did not have any email exchanges during the whole month of July, but just received emails from him, correct?
Sure.
In fact, is it true based on Mr. McDonald's testimony, as documented by his pre-hearing statement, that he filed at the hearing, that you did not respond to him until August 19th, 2020, more than a month after he tried on several occasions to contact you?
That's the question.
Is it true that you did not respond to Mr. McDonald until August 19th, 2020, more than a month after he tried on several occasions to contact you?
Yes.
And do you agree with Mr. McDonald's testimony that after August 19th, he did not receive any emails or communications from Colgate until December 31st, 2020, a full 4 months later, and just a week before the hearing?
I don't remember exactly when in December we re-engaged emails, but yes, it was in December when we were in conversations.
I believe Mr. Padilla and in his questioning pointed out that Colgate sent, Mr. McDonald sent an email to Colgate December 22nd, and that is what initiated the response on December 31st, in which he provided an offer. Is that correct?
I don't have that in front of me, but generally speaking, mid to late December, conversations came back, and
Okay,
I was able to give him the offer that he asked for.
thank you, Mr. Haddock. Does this lack of communication all through July and most of August and the subsequent silence from August 19th to December 31st represent the much more follow-up information that, as you state, someone like Mr. McDonald needs to perpetuate his rights?
I believe we got an agreement done with him, and it only did not close because of Cimarex's objections.
It did not close because of Cimarex's objections?
Once Cimarex filed objections in this case is when both parties agreed to pause.
Okay, well,
Mr. McDonald stated that in his testimony the other day.
I'd like to address that, but I'd like to have a couple more questions before that. Wouldn't it be fair to say that your timeline of communications with respect to Mr. McDonald, stating that you had communications from July 2020 2020 to January 21 misrepresented the facts to the OC during your pooling hearing?
I don't believe that. I don't agree with your statement.
Given the fact that you had one email from July 2020 to December 31st, and then you had the second email on December 31st, you represented to the OCD that you had email exchanges for over this more than 6-month period, but it looks like you, at the number of those months, you had no exchanges. Do you not think that's misleading to the OCD?
It could have been a clearer statement to give the exact months, but we had ongoing conversations with him. So I would not agree that it's misleading. I would say that's maybe overly general or not specific enough.
Fair enough. Mr. McDonald stated on December 31st, 2020, he finally received an offer for the trust interest and the parties reached a basic agreement. Do you agree with that?
There was some back and forth because we had a disagreement on price and disagreement on terms of paperwork. But we did eventually get those impasses resolved.
So Mr. Haddock, if I can direct your attention to Cimarex's Exhibit E as in Edward. You have that in front of you? In this transcript, Colgate Counsel states that the trust and Colgate had reached an agreement. Do you agree with that? That was during the original hearing on January 7th.
Correct, because Mr. McDonald entered an appearance and had initially requested a continuance but then we were able to meet in the middle, or I don't remember exactly what occurred, but pricing issues were resolved. We still didn't have paperwork that he was satisfied to proceed forward.
Okay. And it was this fact regarding the agreement that allowed Colgate to go forward with the hearing by affidavit. Do you agree? And during the hearing, Colgate pooled the trust interest. Is that correct?
They had not signed a definitive document. And
Correct.
we had a verbal or email high level agreement, but no paperwork in place.
And Mr. McDonald said he did not realize the trust interest was pooled. Did you explain? Do you agree with that?
I don't know what you're talking. I don't know where you're.
During testimony of Mr. McDonald during direct, Mr. McDonald said he did not realize the trust interest was pooled. Do you agree with that? That he said that?
Like I've told you before, I don't have the transcript in front of me from the previous, but if that's what it says, then sure.
Did you explain to Mr. McDonald that despite reaching an agreement, you went ahead and pooled the trust, subjecting its interest to a 200% risk penalty and the economic consequences of that?
That was probably, those exhibits were filed before we had reached an agreement with him as far as working interest ownership.
In your discussions with Mr. Donald, did you explain that his interest was pooled and that it was subject to a 200% risk penalty and the economic consequences of that?
We were purchasing it, so it would have been a non-issue.
But if you had listed him as a party to be pooled on the application, would it not be an issue?
We had reached an agreement to buy his interest, and that would have been, the exhibits would have been non-applicable to that interest because it would have been owned by Colgate.
Okay. Mr. Hedrick, are you aware that during Mr. McDonald's direct, I asked a basic question about the pooling hearing, asking whether based on the testimony at the hearing, both Mr. McDonald and Colgate's counsel relied on the fact that an agreement was in place in order to allow the hearing to go forward by affidavit. Are you aware that I asked that question to Mr. McDonald? Do you agree that this is a basic question about polling procedure?
I'm not sure where you're going. I'm not sure what the question or where you're going.
The question I asked is that if they had reached an agreement and there's no objection, this allowed the polling to go forward by affidavit. I asked you, do you agree that that would be a basic question? A basic question about a polling procedure.
Sorry, I'm really confused on what your question is.
Okay. You would have been able to answer that question that I asked Mr. Donald. Is that correct?
We've kind of been rambling. I don't remember the question you asked him now at this point.
Okay, so if I asked you, the fact that you had reached an agreement with Mr. McDonald, Colgate counsel at the hearing relied on that fact that the agreement was in place in order to allow the hearing to go forward. If I had asked you if that was the case, would you understand that question and as a basic question on polling procedure?
I don't know what your question is. I don't know what I'm answering.
Okay, I'm going to move on.
Sorry, yeah.
You were here when Mr. McDonald gave his overall testimony. You were present, is that correct?
Yes.
In your view, in your opinion, would it be fair to say that Mr. McDonald really didn't understand much about the polling process?
Objection. That it's a question that is not even objective in terms of that question should have perhaps been asked for to Mr. McDonald. This is just speculative.
I'll withdraw that question, Madam Chair. I agree with that. Mr. Haddock, in dealing with Mr. McDonald and reading his pre-hearing statement, it was an accurate statement for the time period it covered. That is up until December 31st. Do you agree?
What's the question?
In dealing with Mr. McDonald and reading his pre-hearing statement, which he filed on December 31st, when he filed the pre-hearing statement, you read that statement. Is that correct?
No, I believe he inadvertently omitted a couple of things. I mean, he did reference the offer or several communications.
Which
remember correctly.
So he said that if I remember, he said that he sent 2 emails in July, did not receive a response until August 19th. Is that correct?
We already went down this.
I know, but excuse me. Please, I'll allow you to answer that.
You asked me the same question earlier. I'm not really sure what you're asking me again.
And Mr. Haddock, I believe in the when we discussed this before and addressed that question, I believe you inferred that the pre-hearing statements was accurate.
You're saying you're making inferences on my behalf. I don't really know what you're asking.
Do you agree that Mr. McDonald's pre-hearing statement accurately reflected your 2 emails, which were the only emails you sent over the 6-month period from July 2020 to December 31st, 2021?
I think you're taking our communication out of context and putting a vacuum, siloing it around a very specific, limited amount of discussion.
Am I not just pinpointing the objective facts of when emails were sent and when they were not sent?
You're not pinpointing the balance of the facts.
What is the balance of the facts, Mr. Haddock?
That we had conversations, we resumed conversations in December and reached an agreement on price, and we're working on a form agreement.
Okay.
The hearing.
Let's talk about the series of emails that you sent Mr. McDonald after December 31st. Can we do that?
Thought we did that already, but sure.
Okay, I don't believe we have. Your series of emails with Mr. McDonald after December 31st began a week before the hearing, occurring January 4th, 5th, and 7th, correct?
I think they started on the 22nd of December, but yes.
If I remember right, based on Mr. Padilla's statements, Mr. McDonald sent you a email on December 22nd, to which you responded December 31st. Do you agree with that?
Sure, I don't have that transcript in front of me, but yes, that sounds generally correct.
And then the emails continued for a few weeks after the hearing. Emails exchanged on January 11th, 19th, and 27th, and then on February 1st. Is that correct?
I believe so.
Okay. And not realizing that he had already been pooled, Mr. McDonald says that he and you finished negotiations sometime after February 1st, 2021. And in February, he sent you a signed form to consummate the agreement. Is that correct?
I believe so, but at that point, Simrex had already filed these matters that we're now doing, that we're here today on. So.
And when did you respond to Mr. McDonald to his sending you the signed form? When did you respond to him?
I don't know. I don't have that in front of me.
You don't remember. If I said you did not respond until 4 months later, June 2021, would you agree with that?
Sure.
So, Mr. Haddock, this is an agreement that you negotiated in good faith with Mr. McDonald, who clearly is inexperienced with OCD proceedings, and that is the kind of person that you say needs much more information to help them perpetuate their rights. You negotiated in good faith an agreement, and then you did not consummate it, correct?
This whole order was in question at that point, and it still is.
Well, Mr. Haddock, why would that make a difference to honoring agreement that you agreed to, that you relied?
Because there was a material change in circumstances prior to, closing that transaction.
Okay, and that's from your perspective, correct?
Well, it's not a perspective. It's Simrex had filed proceedings that were calling in this whole spacing unit into question, and as even Mr. McDonald said, he wasn't that interested in going forward at that point because he was aware of those.
Okay, so when you responded to Mr. McDonald in June and said you were ready to proceed, as you point out, these de novo proceedings were in progress, correct?
Yes.
Could your delay?
Did you respond to that, Mr. Haddock?
Yeah, I'm sorry. Mr. Haddock, please respond to that. Please take the opportunity to respond to that.
I don't know what's the question. Was there a question or was it just a statement?
Okay, I'm going to move forward with my questions here and withdraw that last one. In your experience with the pooling process, when a party makes an appearance and consents to pooling by affidavit, it would be very difficult to overturn the pooling order. Do you agree with that?
It depends on the circumstances. I mean, what are you just saying generally when someone makes an appearance?
Generally speaking, is that correct?
Someone enters an appearance and has effective notice and enters an appearance, then correct.
So would the fact that you pulled Mr. McDonald's interest have any bearing on the delayed response after he sent you the form, the signed form?
Sorry, you cut out for a second. What was that question?
Would the fact that you pulled Mr. McDonald's interest have any bearing on your delayed response, 4-month response, after you sent the signed form?
No, as we already discussed, the de novo component put a lot of things on hold because management didn't give me authorization to do anything else here until we had some sort of bearing on what was going to happen.
Prior
De
to
novo
filing,
proceedings.
thank you, Mr. Haddock. Prior to the filing of Mr. McDonald's pre-hearing statement on December 31st, 2020, you had only one email exchange with Mr. McDonald. That was August 19th. But after he filed his pre-hearing statement, you suddenly had multiple email exchanges with Mr. McDonald during that last week before the hearing. Is that correct?
Correct.
Those email exchanges, which occurred on January 4th, 5th, and 7th, how many emails did you send on each day? Do you know how many emails that represented?
Oh, I've already told you I don't have that email chain in front of me.
But quite a few, would you agree? In fact, I believe Mr. Padilla said that you had responded with more than one email on the same day, responding to Mr. McDonald. So,
Mr. Savage,
yes,
one, the witness hasn't responded, so please don't move on. Two, can you keep your testifying to a minimum, please?
I just have 3 more questions.
Right, that's fine. You can ask as many questions as you need to, but keep them as questions and limit your testifying for the witness.
Yes. Thank you, Madam Chair. I will watch that. May I proceed?
Yeah, please go ahead.
So, did you suddenly shift gears to reach out and respond to Mr. McDonald because he had actually filed a pre-hearing statement that threatened your application and you knew he was serious?
We had engaged with him prior to his pre-hearing statement. I believe.
Okay. That over the course of that 6 months prior, you only sent one email, correct?
Wasn't talking about that. I was talking about the December emails, if that's
Correct. So that was December 31st. You received his pre-hearing statement on December 31st, correct?
I believe so.
And that's when the flurry of emails began, correct?
Sure.
So the record shows that
Sorry,
when
what did you say? Did you say sure?
Yes. He keeps
Is that
answering my
yes or
questions.
no?
Keeps answering my questions. He asks the question and then and then says correct, yes or no, or he doesn't add. Let me rephrase that. He asks a question and then answers it for me. Not
Mr.
sure.
Savage, will you re-ask the question, and Mr. Haddock, will you re-answer the question, please?
Yes.
Yes, Madam Chair. Did you suddenly shift gears to reach out and respond to Mr. McDonald because Mr. McDonald actually filed a pre-hearing statement that threatened your application. And you knew he was serious. Is that correct?
Yes.
So prior to filing his pre-hearing statement, would it be fair to say that you did not take him seriously?
I would not agree with that assessment.
Would you agree that the flurry of emails that occurred from December 31st to the hearing that week were in response to the filing of this pre-hearing statement and the effort to protect your interests in the pooling hearing?
To reach an agreement with him so that we could proceed.
And those did not occur until you realized that you possibly may not be able to go through with your pooling hearing. Is that correct?
Not really sure what I'm not following the questions there.
Prior to December 31st, you sent one email on August 19th to Mr. McDonald. After December 31st, you sent multiple. During that week, you sent multiple emails. Would it be fair to say that those were motivated by your concern that you would not be able to go through the pooling hearing unless you resolve this issue with Mr. McDonald?
It's a standard practice to work with the parties all the way up through the hearing process. Sorry, from the filing to actual hearing. And as you know, many times they get continued because discussions are ongoing.
So the record shows that when you are motivated to get all of your interests in order for the pooling hearing and the subsequent pooling order, would it be fair to say you're very capable of reaching out and responding immediately numerous times to working interest owners?
I believe you're inferencing again, and I'm not going to agree with your statement.
The statement basically says that the record shows that you have the capability when you want to reach out numerous times and negotiate in good faith. Would that be correct?
I've already answered that I'm not going to agree with that statement.
Mr. Hedrick, overall, would it be fair to say that Colgate dropped the ball with Mr. McDonald in the same way that it dropped the ball with Cimarex?
Strongly disagree with all of your statements there.
Thank you, Mr. Haddock. I appreciate your time and efforts to answer all my questions. I have no more questions, Madam Chair.
Thank you. Commissioners, do you have questions for the witness?
Yeah, Madam Chair, I do.
Go ahead.
Greg, do you want to go first?
I have no questions, Madam Chair, so Commissioner Mpoma, please go ahead. Thank you.
Thank you. Mr. Haddick, I do have a couple of questions for you. So can you tell the commission how many interest owners did you send the well proposals to?
I don't have the exact count of parties in there, but anyone who is a working interest owner in that spacing unit would have gotten a well proposal.
So how many of them were you able to get agreement with them to participate under the JOA?
I acquired several parties via purchase, and then several parties, and Concho being one of them, had indicated that they wanted to participate under the order and were fine with proceeding the hearing.
Okay. Yeah, so I want to ask, how do Corgi describe their good faith efforts, in this particular situations or in general?
typically, I mean, in my view, is we send the proposal. It's the initial trigger of communication to let people know what we want to do, and this is this is an old area, so there's typically lots of parties. So that usually triggers phone calls and emails from parties because it'll have our contact on there, and then sometimes it's a simple question and and you don't ever hear from them again, or sometimes the parties want to participate. If they request a JOA, we will send a JOA. They just prefer to participate under the order, then we'll school them, and then a number of times parties want to sell, and if we can reach an agreement there, then we'll gladly buy their interest. If there's and pass on terms, then we end up going to the hearing.
Yeah, so my last question is, was there a timeline for companies to respond to the work proposal?
Well, I mean, you can't file for hearing until there's been at least 30 days of lapse since notice of hearing. I mean, sorry, can't file for hearing since more. My brain's not working. You have to wait 30 days from sending well proposals before you can proceed to hearing.
Thank you, Mr. Hadich. Madam Chair, do you not have any further questions for the witness?
Thanks. I just have sort of one additional question building, I think, upon Dr. Mpuma's question. So what would you expect if this were flipped? If you were the one being pooled, what is your expectation for the interactions from the other operator?
Operator to operator, if they didn't respond, I would not, or had very limited response, I would not be at all surprised if they proceeded to hearing without further contact. In fact, that happens all the time. Operator to operator, where the parties have an understanding of the process and the implications.
So what you're stating is if you didn't respond or ask questions or engage, then you would expect the other operator to just move forward.
Correct.
Okay.
Sorry.
Go ahead.
In fact, I would almost say that's a standard practice. I mean, we get a number of MUBURN and EOG proposals, and that typically might entail 1 or 2 emails at tops, or no emails before hearing notice is sent.
So do you believe that in this pooling application, you engaged in good faith efforts with Cimarex?
I believe so, because historically, when I work with another operator, I've responded to them and they don't respond back. I assume they don't have any other questions or objections to what we sent. So I felt that they were fine with proceeding forward. And
so building on that, it sounds like you take no response as agreement.
or not objection, or no objection to proceeding, or in the case of not being taken seriously, then usually the hearing notice will then trigger a real conversation, because what we've seen historically is a lot of times parties don't want to commit unless there's a hearing impending, and then that results in a number of continuances and actual negotiations at that point, because parties don't want to move their lands around or sell their lands unless it's truly going to go to hearing and it's not just a pandering proposal. Because there has been.
Oh, I'm sorry. Go ahead.
Because there was a period of time over the years where fly-by-night operators would send out proposals to try to shake down interest from parties. So I can understand potentially why nothing gets taken, why certain parties may not take it seriously until hearing notice is filed.
So after after this was noticed for hearing, did you have any additional contacts with Cimarex?
Not with Cimarex.
Did you with other operators?
Yes, we've got Concho, Mr. McDonald. We bought out a couple of other parties in there as well.
So again, from your perspective, there were multiple opportunities for Cimarex to have engaged and they did not?
Yes.
Okay. I don't have any further questions. Commissioners, anything else before I pass back to Mr. Padilla?
No, Madam Chair, I did have a question, but then you asked us, so thank you. I'm set.
Okay.
No, Madam Chair.
All right, Mr. Padilla, do you have redirect for your witness?
Just a few questions, Madam Chairman. Mr. Haddock, looking at our Exhibit 2, which is the email stream of the two emails that went back and forth. Do you have that in front of you?
Yes.
Okay. Can you tell us what the subject matter of that those emails were?
Intention was to clarify what our development plan was and ask what.
No, I want you to. Well, let me ask this way. I want you to look at the email that you send out, and at the top of the email, it identifies who the email's from, who it was sent to, and the subject. And the subject is Meridian Proposal.
Correct.
What is that about? That's about this particular well, right?
Yes, that's the name of the well.
And when Mr. Kaufman sent you his email, it also referenced the Meridian Proposal, correct?
Yes.
In Mr. Savage's questions to you, he implied that perhaps you were talking about some other proposal, but clearly you would agree that you were talking about the Meridian Proposal, correct?
Yes.
Okay. You also testified in an answer to Mr. Mayba or to Mr. Savage's questions about JOAs. And I think you mentioned Mewburn and another company that don't typically send JOAs. Which companies were those again?
I believe EOG doesn't always send, or they used to not. I haven't received one recently, and then I've not always received JOAs of Mewburn's proposals either.
And they're big guys, right?
Correct.
Tell us the Concho decision. You stated in cross that they told you that they would proceed under the terms of the order. Is that correct?
Correct. We had been in discussions to buy their interest or trade it, and they decided they would want to participate, but hadn't, but didn't request the JOA and agreed to let the hearing go forward.
So they would participate under the terms of a compulsory cooling order, right? Yes.
Yes, sorry. Excuse me. Sorry. Yes.
Essentially, anyone can participate under a compulsory cooling order, right?
Yes.
And how do you go about doing that?
Send out post order proposals, pursuant to the order.
If I was a working interest owner who got pooled, could I participate under the terms of a compulsory cooling order?
Yes.
And do orders have a time period to elect to participate?
Yes, they're very similar to the terms of a JOA.
So when you, in questions posed to you by, I think, the chair, you essentially said that the notice of hearing triggers discussion, right?
Correct. Any discussion that hadn't been resolved usually triggers parties to continue discussing or object.
Would you characterize that as practice and custom in the industry?
Yes, there's a number of cases we're involved in that have been pending for years because parties have had discussions ongoing following the filing of the order. Filing for hearing.
Now, you were questioned extensively by Mr. Savage about the Prosperity Bank issue. Who followed up on your proposal to Prosperity Bank?
What do you mean? Sorry.
Well, let me ask the question. Mr. McDonald followed up on your proposal, correct?
Yes.
And he didn't just sit on it. Is that fair to say?
Yes. I mean, and to the extent that it did sit, we resumed conversations after that hearing notice went out.
Mr. McDonald was pretty persistent in the number of emails that he sent to you, right?
Correct.
Madam Chair, I think that's all I have.
Thank you. Okay, so I just want to do kind of a scheduling update here and maybe take a 5-minute break. Almost been going 2 hours. We are going to need to break today from 11:15 to 12:45. It's 10:40 almost. Commissioners, are there any of the previous witnesses you would like to recall before we ask for closing and we talk about the motion?
Madam Chair, I have no witnesses that I need to recall. Thank you.
Madam Chair, I do not have any witnesses that I would like to recall.
Okay.
Thank you.
So I think, all right, so it sounds like we're probably done with witnesses. We could move into closing. And we also need to hear the motion pieces.
Madam Chair, if there's no, I haven't heard you ask, but assuming there are no additional witnesses for the parties, you could close the evidentiary record at this point, and then because closings are not evidence, they're argument, and the motion is not evidence, nor is it gonna proffer any evidence. I don't think. You might check with the parties on that as well.
Mr. Padilla, I believe that was your one and only witness. Am I correct?
That's correct.
Okay. All right, then let's close the evidentiary hearing portion of this. Let's take a quick 5-minute break. Be back here at 10:45. And then let's talk about the motion. I will ask that the counselors be somewhat brief because we do have your motions and replies. But I'll give you both an opportunity to discuss that when we come back at 10:45.
Okay. Or initial jurisdiction over a compulsory cooling case. You clearly start at the division, then you go up once you're an aggrieved party. And so I don't understand where we're headed with this kind of thing. The venue thing is just baffles me. And the district court, if you're filing a lawsuit against somebody, the venue statutes are very clear as to where a plaintiff might file a proceeding. Generally, it's where either the plaintiff or defendant lives. That's what venue is. Here, I just don't understand where we're coming from. Now, in terms of the citation of the Uden case, that case involved a unit agreement where the participation for royalty owners and overriding royalty owners who were not noticed in the hearing was going to be changed because of the contraction or expansion of the unit. I think it was an expansion case. Therefore, the interests of the overrides and the royalty owners was going to be diluted. So I just don't see a connection how you can have a third option here, some kind of choice of going back to the division. Obviously, we're going to abide by whatever the commission is going to do in this case. I don't want to. We were very repetitive in our response in terms of procedural history and argument, but I don't think there's a third option here. You're either before the division initially, then the commission, then if we get to that point, and it's serious enough, we can have judicial review of it. I think that we have some judicial review of this order, because I think that when Cimarex did not appear at a hearing and they had notice, then they then they're out. The commission has ruled that they're entitled to de novo hearing, so we'll abide by that. That's what we're here for. But this question in this case is solely on the issue of good faith. So I don't want to argue closing at this point, but as far as the motion is concerned, I think it definitely needs to be denied. I mean, first of all, I mean, at this late stage, you're bringing that up as a procedural issue when everybody has had notice. So I implore the commission to deny the motion.
Mr. Padilla, this is Mr. Monder. I just want to clarify, make sure I understand your position on this. Independent of the motion, is it your position that the commission does not have the power to sever a party out of a division level order?
I don't understand the question entirely.
Okay, let me kind of lay this out because then this is again based on my understanding. I'm not adopting Mr. Savage's position. So generally, like with agreements and contracts, or even orders, courts usually retain, and I'm speaking of courts, not necessarily the commission here, but courts have the ability to sever provisions out or amend or alter a lower court or lower level order. I've seen that done with both orders and contracts in my career. And so what I'm asking you is that regardless, I'm looking for a more general concept here, whether it's you or your client's position at the commission, taking the subject order would be prohibited or barred from, say, for example, severing out, shoot, I'm not going to get these names wrong. Is it Cimarex and the trustee? Was the commission barred from doing that, removing them out of the order, and then, just for the sake of completeness, remanding the matter to the division?
Well, that's what the commission is doing, remanding or may remand them. But it's effectively, we're here at this evidentiary hearing on some sort of a remand to determine whether on the issue of good faith. But that is before the commission. And I think a remand to determine good faith before the division after the hearing has already occurred before the division is inappropriate simply because the statutes don't call for that kind of remand or review. The procedure is for a de novo hearing, and it goes before the commission, and you retry a case as though it's a new case, but it's before the commission. I could see statutory authority to remand back, or even the rules don't say that. Now, I suppose we would be breaking new or precedent if the commission ruled that it would remand for determination as a Cimarex and Prosperity Bank. But I don't see how in the world Prosperity Bank can complain here. I mean, with Cimarex and the practice and custom between companies, I think Mr. Hadjick's statements that the hearing notice triggers a lot of discussion afterwards. That has been my view. That's when I get engaged, not at any other time in compulsory pooling cases.
Commissioners, or Mr. Vidia, are you done?
I'm done.
Commissioners, do you have any questions for either Mr. Savage or Mr. Padilla on this motion?
Madam Chair, I do not. No, thank you.
Madam Chair, I do not.
I just have one question, Mr. Savage. So you're saying third option, what would that practically do for your clients?
Madam Chair, thank you. I think there's some misunderstanding here. Let me go over the three options that are available to the commission. And when we started out with this idea of an evidentiary hearing. So the first option is Colgate is found not to have negotiated in good faith and failed to make attempts. Under those conditions, when we started this proceeding, we it was on the premise that that would invalidate the order as a whole. And that would require, and because there's no standing order to be heard de novo, that would require a return to the division to start from scratch to allow the competing applications between the two parties. Okay. The second option, and this was under the original premise, is that Colgate is found to have engaged in good faith negotiations and to have made attempts to reach an agreement. Under this condition, the order would stand, and with a standing order, the commission would have full jurisdiction as a forum to have the de novo hearing and to hear the competing applications. Then there's this third area, and that would be that Colgate is found not to have engaged in good faith negotiations or made attempts. In that case, the order would be void as opposed in regard to Cimarex, but the order would still be valid and standing for the remaining owners. Now, I think with a valid and standing order for the remaining owners, even though it may be void to Cimarex, it does not need to be returned to the division. It could be the commission could assume jurisdiction and have the de novo hearing and hear the competing applications. I think that provides the full scope of authority for the commission. Now, how that benefits Cimarex. It would benefit Cimarex in the scenario where if the commission is on the fence and is having a very difficult time deciding whether or not Colgate engaged in good faith negotiations and made attempts or whether it not, it would relieve any pressure of the consequences of where that forum would end up based on a decision by the commission. The commission would be free without pressure because they would know that they could choose whatever forum. That's basically the benefit as I see it.
Okay, maybe I'm not understanding that. I'm not sure.
Mr. Savage, so, all right, let's just say, I mean, I've been using severance because that's the term, legal term that seemed to stand out to me or be applicable. So what happens if, as you described, Colgate is not found to have acted in good faith, and the commission finds that the order is void as to Cimarex? Where does that leave Cimarex here? Because I don't think that's the end of the story. In fact, I think that's the beginning of a brand new story. You want to get to that.
Yes, that would Cimarex. We would still be under because of the order of standing. I believe that the commission would still have jurisdiction over the de novo hearing, and I think that the commission would have authority and power to address at the commission level that defect through a hearing of the competing applications, which would ultimately decide who is bound by what order. The commission has concurrent jurisdiction with the division. I don't think that it's absolute, but I think it's very broad, and I think the commission has interpreted it to be very broad.
Thank you, Mr. Savage.
Madam Chair, Mr. Moander, how do we proceed from here? Is this all something we can discuss in deliberations, or?
This would be a motion. So let me just double check, but I think this would not fall under the ANOMA exception, and so this would need to be discussed on the record. But if you'll give me just one moment to do one double check, I will opine a little further.
Okay. While you're opining, my other question is the way that Mr. Savage lays it out, it's more of a third option after we've sort of decided where we are in deliberations. However, well, I'll just make that statement.
And Madam Chair, I would describe this, and either council is free to correct me on this, but this appears to be a variation of a remedy that would be applied or not applied after the commission makes substantive findings. I'm not asking anyone to take a position on the merits, but does that sound correct to either side?
Mr. Moander, I think that's a very good description. It does not affect the substance of the evidentiary hearing, but it gives the commission options of what to do after a finding or conclusion.
So it's maybe something we should discuss after deliberations, is what I'm hearing. But we may need to discuss that after deliberations on the record and not during deliberations.
You could go that route here. I mean, Madam Chair, if you've got, yeah, that could be done. Madam Chair, I'm going to need a couple of minutes here. I just want to check on one narrow issue in the nature of this motion. Could we take maybe 5 minutes here?
Yeah, we can take 5. We're going to have to break from about 11:15. Stay on a couple extra minutes to about 12:45 or to 12:45.
I think it's up to you, Madam Chair, how you want to do this.
I mean, we could go ahead and break now, and you can research that, and we can discuss when we get back.
I mean, that's fine. I mean, because I think I'll have an answer that should probably, at least we'll know what we need to do next steps in terms of addressing the motion. And so I'm okay with that, recognizing that there's still a ruling that needs to get made and deliberations to conduct today.
Okay. So why don't we do that when we come back at 12:45? Mr. Moander will update us on kind of where we're at with the process for the motion discussion and decision. And then Mr. Savage and Mr. Padilla, you can do your closings. And then likely the commission will go into deliberations, potentially. Does that sound like a plan for everybody?
It works for me.
Right. Great. I will see everybody's bright shining faces at 12:45. Thanks. All right, so I think where we ended was, Mr. Moander, you were looking some stuff up, and then we were going to get started on closing statements.
All right, so Madam Chair, I just wanted to be sure, my main concern was a motion that's in the middle of a hearing versus a regular motion hearing. And so it's my understanding of the law that the commission can go into closed session to deliberate on the motion, so that there's no prohibition on that deliberation happening within the confines or context of a larger hearing. So the commission may deliberate in closed session momentarily to include both the merits of the case as well as the motion.
Okay. Thank you for checking. All right, with that, I think it sounds like since we can talk about that in closed session during deliberations, we can discuss that as well. Okay. All right, Mr. Savage, would you like to make a closing statement?
Thank you, Madam Chair. I would. Madam Chair, Commissioners, Mr. Molander, Council. The idea of negotiations being a two-way street applies in a general sense to the meaning of negotiations, but it does not fully capture the legal criteria of the Oil and Gas Act and the rules that uphold the intent of the Act. It is very clear under the rules that the applicant, Colgate, must make and show attempts to gain voluntary agreement. That part of the division's mandate is the short one-way street the applicant must go down before it can exit onto the two-way street where negotiations are held. Clearly, by a preponderance of the evidence, Colgate failed to do this. During this evidentiary hearing, we looked closely at the one email exchange between Cimarex and Colgate, which Cimarex, not Colgate, initiated. Now, there is no expression of an attempt to gain voluntary agreement in Colgate's very short email response, not even the implication of an attempt. After the email exchange, Colgate never made an attempt to even negotiate with Cimarex. Now, it is unheard of in the industry that an applicant such as Colgate, faced with needing to commit substantially the same amount of working interest from an owner that the applicant itself owns, in this case, a full quarter of the unit, would not reach out to the owner, Cimarex, with attempts to voluntarily pool this substantial amount of working interest. Colgate has had a history of past dealings with Cimarex, knows that that Cimarex routinely objects to and protests Colgate's attempts to pool its interests, and knows very well Cimarex would have never agreed to having its substantial 25% working interest pooled. No way would that have happened, which is maybe why Colgate didn't engage in good faith negotiations. What Colgate is asking the commission to do is to put the burden and obligation on Cimarex to make attempts to reach a voluntary agreement. Putting the burden and obligation on Cimarex to reach out to Colgate instead of vice versa turns the Oil and Gas Act and the division rules on their head. Under the rules, the burden, that is the clearly stated obligation, is on Colgate to affirmatively reach out to Cimarex with efforts to gain voluntary agreement. Colgate did not. Colgate initiated the pooling process with its mandatory well proposal that lacked a JLA and then failed to play by the rules, or more seriously, to play at all. Therefore, Colgate has forfeited its right to have been awarded a pooling order that binds Cimarex's working interest. Colgate's argument that Cimarex dropped the ball by not reaching out to Colgate after the August 2020 email exchange is untenable, irrelevant, and immaterial. By Colgate's own admission, it is common for working interest owners not to take seriously a well proposal that is missing a JOA without evidence of further serious negotiations initiated by the party who sent the proposal. Colgate's admission corresponds exactly with the process that Cimarex uses and by clear implication with what other working interest owners use to triage and assess the numerous well proposals that working interest owners receive in order to determine if the proposals are serious or not. A high percentage of the well proposals received never go to hearing. Under the facts of this case, by all indications, it was reasonable for Cimerex to have assumed that Colgate's proposal was not serious. Cimerex did not drop the ball by using its ranking process. It was just waiting for Colgate to serve the ball. Colgate has repeatedly pointed out Cimerex's fault for missing notice, and we assume Colgate will again point this out in its closing statement. But this fact, which Cimerex has never denied, only proves Cimerex's point that without a notice in hand, for whatever reason, whether it wasn't mailed or whether it was accidentally missed by the intended recipient, it is reasonable for a working interest owner not to take a proposal seriously if it does not have a JOA, or if the operator does not demonstrate through good faith negotiations attempts to gain an agreement that the proposal is in fact serious. Colgate did neither. It did not provide a JOA, nor did it reach out to Cimerex to engage in good faith negotiations. Instead, after sending the mandatory well proposal, Colgate laid low under the radar. Applicants can often get away with this strategy, laying low. It often works until an applicant is challenged on the practice, as it was in this case. By asserting its rights, Cimerex has shown that it is not the only victim of such practices, but Mr. McDonald also fell victim, as unwittingly for him, the working interest he holds in trust has been force-pulled without his full understanding of what that means or could mean for the interest. What we see with Colgate is a pattern of misrepresentation. You see it in Colgate's communication timeline that excessively overstates the scope of communications that actually did take place. And you see it in Colgate's pooling applications and exhibits. When you compare its statements that it sought voluntary agreement from Cimerex, when you compare that to Colgate's actual absence of attempts to gain voluntary agreement from Cimerex. And Madam Chair, this is why this case should be important to the Commission. It is a clear opportunity to affirm the standard of, first, what constitutes attempts by the applicant to gain a voluntary agreement, and second, what constitutes good faith negotiations, both under the rules and the intent of the Oil and Gas Act. Is the standard a bare minimum standard consisting only of sending out a well proposal without a JLA and then offering a two-sentence generic email response that makes no attempt to negotiate an agreement, followed by months of complete radio silence? This is what Colgate argues. Cimerex submits that adopting Colgate's position would result in no standard at all. Or should the standard be slightly higher? That is, at least a well proposal with a JOA, followed by at least one good faith attempt to gain a voluntary agreement. Or if the well proposal does not include a JOA, then at least the showing of a couple of good faith attempts that indicate the proposal is a serious proposal. This slightly higher standard would be little, if any, burden on an applicant who intends to act in good faith anyway, and it would uphold and maintain the integrity of the pooling process. To protect the correlative rights of owners, Cimerex respectfully requests the Commission respectfully requests that the Commission adopt a higher standard, at least slightly higher than what Colgate proposes, that will still keep the burden on the applicants to a minimum. And in doing so, the Commission should find that Colgate failed to make attempts to gain voluntary agreement. And because of Colgate's silence and unresponsiveness, the Commission should find that Colgate did not negotiate in good faith. Thank you.
Mr. Padilla.
This hearing involves what is good faith and under the compulsory pooling statute and the rules of the division. I find it incredible that Mr. Kaufman testified that one more email would have been sufficient to satisfy good faith. I mean, when you look at these emails, which involved the Meridian proposal, the well under consideration that was for which Colgate made the application, they could have come back and said, we propose a contract area larger than the spacing unit under consideration. Cimarex claims that the burden is on Colgate in this case. Well, if you send a proposal and you're the target of a compulsory pooling application, I think you have to act like Mr. McDonald did. He sent emails to Mr. Haddock. He chased the rabbit. What did Cimarex do? They effectively threw the proposal in the trash because it didn't have a JOA. Yet testimony here today indicates that a JOA may or may not be accompanied by a well proposal. But it is clear that upon request, the JOA is normally sent in the oil industry by someone who is trying to force pool working interests. Cimarex can't simply say, well, the ranking we gave this thing was very low because it didn't have a JOA. Ultimately, you're going to wind up in a compulsory pooling application, which happened in this case. And like it handled the well proposal, they did nothing in terms, they mishandled it. You can argue all day long, but the rules did not change because of COVID, did not change in any significant manner as far as hearings and applications and filing. We just went online and did it that way and went virtual on the hearings. Not only that, but when COVID was on, the division actually suspended a lot of hearings for a period of time. We didn't have any hearings, and they were all suspended. So even though Mr. Savage tries to make this case into some kind of a force majeure case, that there were circumstances that prevented their performance, they still dropped the ball. They dropped the ball, and I'm not trying to do a metaphor. Let me just say they omitted handling the well proposal. They omitted handling the notice of hearing. Custom and practice amongst the Colgate, Cimarex, EOG, Mewburn is that JOAs are not always sent with a well proposal. I've been involved in many compulsory pooling cases, and you don't always have, in putting together a package for compulsory pooling, you don't always have a JOA. You don't even have JOA as exhibits. What is required by the rule is a well proposal, which generally contains an AFE and an election page to elect or not to elect in drilling the well. Cimarex didn't send anything back saying it did not elect to participate or do anything. They trashed the application because they, as they say, it did not have a JOA attached to it. But going back to Mr. Kaufman's testimony, one more email would have done it. I mean, that just doesn't make any sense. Now, going to the Prosperity Bank issue, you can't even compare those. I mean, whether or not Colgate communicated more often in December, that's just the way things seem to happen, and that's just the way, especially amongst larger companies like Cimarex, Colgate, Mewburn, EOG. EOG's a big player, and they apparently don't send JOAs with their well applications. They will. I've represented EOG on compulsory pooling cases, and I don't know, I can't remember specific cases, but it's not a material issue as to whether or not a JOA was sent. I've never handled cases where a JOA was part and parcel of the evidence that had to be made by a well proposal. An AFE, of course, I think is required. You need to know how much a well is going to cost or what is proposed, and it depends on what formation and the target of the application. But I can't get away from this practice and custom, and it's typical that people do things at the last minute. I don't think that we're setting any new precedent here in terms of good faith amongst major operators. I can't understand why Prosperity Bank is even in this case, especially since Colgate continued beyond the hearing date to contract with Prosperity Bank. Mr. McDonald agreed with me that there were a whole bunch of emails between the parties, but the difference between Prosperity Bank and their interest and Cimarex, an experienced major player, are two different things. So you can't take good faith is relative to experience in the industry. Cimarex had it, and it's incredible that they did not pay attention. They essentially trashed the proposal. You can't sit here and come here and say, well, we didn't consider it as being credible. No JOA. So we're going to put it at the bottom of the stack. They didn't even discuss it in their team meetings. They never even brought it up. But the proposal was there. It never went away. And why they didn't appear at the division hearing is not Colgate's fault. If they'd have handled it, they'd have probably got a continuance from Colgate to discuss this further, and that happens all the time. So I don't see that we're breaking new ground here, or that the division ought to set some kind of list, a checklist of what is necessary and how many emails have to be made. It's all an objective deal between companies, especially where, like Cimarex, owned approximately 25% of the prospect. They didn't lay low. They made the well proposal, and Cimarex simply ignored it. the motion should be denied. Or this hearing, Colgate should not be penalized in any manner. And we should proceed to a de novo hearing, not any remand back to the division, and try to decide how many options there are in terms of how the division handles or the commission handles hearings. Thank you.
Thank you, Mr. Padilla. Oh, hold on. All right. So we already closed the evidentiary hearing, but I think the record of this application hearing is now closed. Commissioners, I would propose we go ahead and deliberate on this case today, this afternoon, immediately following this. We will need, I think, to make a motion, but I guess, is there a motion to close the meeting pursuant to the administrative adjudicatory deliberations exception to the Open Meetings Act, sections 10-15-1H3 to deliberate in this case?
Madam Chair, I so move.
Is there a second?
Madam Chair, I do second.
Would you do a roll call vote, please, Mr. Molander?
Yes, Madam Chair. Commissioner Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair.
Approved.
And with that, the motion carries and the commission may proceed into closed session.
Okay, so I'm going to leave this up and running. Commission, I sent out a separate meeting invite. You're welcome to cut off of this if you'd like. I'll stay logged on. So everybody should just be able to stay on here. It's 1:10 now, so I will pop back in an hour at 2:10 just to give everybody an update. And we may, depending on where we are, keep deliberating or come back. So at 2:10, please, everybody plan to pop back on for an update. All right, thanks everyone.
Thank you.
Again, it's 2:13 on March 10th, 2022.
And Madam Chair, we'll need a motion.
Yeah.
Okay, just making sure.
Is there a motion to go back into open session?
Madam Chair, I move to go back into open session.
Is there a second?
One second, Madam Chair, we need to be a little more specific on that motion. That motion would need to verify that the only matters discussed during the closed session were those that were outlined in the motion to enter deliberation.
Is there a motion to go back into open session and that the discussion during the closed session was limited to deliberation in case number, case number 21744.
Madam Chair, I so move.
Is there a second?
I second.
Okay, now we do a roll call vote, please, Mr. Molander.
Yes, Madam Chair. Commissioner Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries and we are back in open session.
Okay. All right, in the matter of de novo case number 21744, is there a motion that Colgate did enter into a good faith effort to secure voluntary unitization by the sending out the AFE and well proposal, as well as in the letter provided in Exhibit B5 by Colgate, additional timelines and contact info, and that the commission readopts the standards set forth in order R13165, which has been utilized in other compulsory pooling cases and orders since. Based upon the timelines that were lined out in Colgate Exhibit number 5, Cimarex did not reach out within the required 30-day timeline, as indicated in the letter, and therefore Colgate did not elect within that timeline, and Colgate was in their rights to move forward and force pool Cimarex.
Madam Chair, I so move.
Is there a second?
Madam Chair, I second.
Would you do a roll call vote, please, Mr. Melander?
With pleasure, Madam Chair. Commissioner Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
Additionally, there was a motion by Cimarex. This motion is denied and is moot based on the evidence that was presented and ultimate consideration by the commission. Is there a motion?
Yes, Madam Chair, I so move.
Is there a second?
Madam Chair, I second.
Mr. Moinder, would you do a roll call vote, please?
Absolutely, Madam Chair. Commissioner Mpoma,
Approved.
Commissioner Bloom,
Approve.
Madam Chair,
Approved.
the motion carries.
The motion
Madam
to
Chair.
deny the motion, just to be clear, carries.
Yes. Madam Chair, did you intend to discuss next steps in the original motion of your findings, or were you going to address that independently? You can do it independently at this point if you want.
As in like timing for the order and that?
No, what next steps this case may or may not have.
Should that be addressed in a motion or
You
just?
know what, you're right. It probably shouldn't be because I think that matter's already been roughly decided. So, okay, I'll withdraw my comments on that. Just trying to be extra thorough.
Okay. I think we will, Mr. Moiner, are you drafting the order in this case?
Yes, Madam Chair.
Okay. And we can discuss and review that order for potential approval at the April 14th, 2022 hearing date.
Yes, Madam Chair.
Okay. Are there any other items we need to discuss on this case before we move into the remaining agenda items?
That's what I was getting at, Madam Chair, is whether this case, and now I realize I'm drawing a blank on this. Are there going to be further hearings in this matter, or in this case?
I believe we have another case. Ms. Davidson is the next Cimarex Colgate case. When is that currently scheduled?
It's scheduled for April.
Okay.
For the April 14th date. Okay. Mr. Moyner, are we allowed to ask the parties if that is still their intention?
Sure. I mean, you
Okay.
can ask them pretty about anything you like at this point.
Madam Chair,
Miss-
Madam Chair, I'm sorry, just to clarify, are we talking about in April doing the de novo hearing related to 21744? Or is this yet a separate Cimerex versus Colgate case?
I believe it's related to this same issue, but it's a separate case. But maybe Mr. Savage and Mr. Padilla, if you could just provide a brief status update to the commission on that, and if the intent is still for that to move forward on the 14th.
Chair Sandoval, I misspoke. It was originally scheduled for April. It's been continued to June 9th. The de
Okay.
novo.
I'm
Okay.
sorry, I didn't catch that.
Ms. Davidson said it's been continued to June 9th.
Okay.
Okay.
Madam Chair, did you want me to go first on that?
Yeah, if you just want to provide a brief update on that.
So, as I would understand this now, the status of the case, that we go forward with the de novo, and part of that de novo is the competing applications of Cimerex, in which they have proposed competing applications and development plans that, in our opinion, are superior to Colgate's plans, and that they promise greater production. We feel that the commission has an obligation to review those for the protection of correlative rights and the prevention of waste. I've been talking with a geologist, Kate Pickford, about the pools in that area and in the subject lands for Cimerex, and there's some ambiguity about the pool codes, and we want to make sure that we do not have overlapping units that have to be accounted for. So I'm working with her, and I need to amend those applications based on her feedback, and I will submit those as soon as I can. But we would have to, once submitted, we would have to provide for time for notice for those applications. Hey, can you hear me?
Sure.
I was the one who was muted.
Yeah.
I'm just talking to the wall. So I was just asked if Mr. Padilla, if you had any additional updates on the case.
No, I don't. I would have to confer with Colgate, but seems to me we may have, we're going on now June 9th. There were, I don't know what the propriety is in terms of Colgate, Cimerex filing its applications, competing application, and it did not file before the division. The issue would be whether or not, as far as I see, if they're based on the commission's ruling today, that good faith was on good faith, that I'm not sure that Cimerex can come now and file for de novo on its application. No question, de novo on the Cimerex issue, and they can contest that on a de novo hearing. Whether or not they can now come and file applications after the fact is questionable, but I don't want to belabor the commission on that. If we do something, we file a motion addressing that issue.
And Mr. Padilla, I'm glad you pitched that option because this case is it's extremely heavy on procedure, I think. I think some motion practice on that, given there's 2 months before the next setting, would be appropriate. What I would recommend, and obviously Madam Chair can make the call on this, but is that have the parties discuss who wants to. What I would not like to see is 2 motions and then the 2 replies and 2 responses and 2 replies that retread the same ground a bit. I'm not sure how to necessarily go about that, Madam Chair, but I think that would be helpful here in making, because I do think there's some, it would be helpful for the commission to get some more information and some argument from the parties on that next step.
So would those motions be, they're like another date, right?
Yeah,
Okay.
No,
Great.
I'm not.
That's okay.
There's been enough intellectual horsepower between everyone involved in this for one day, I think.
Chair, Mr. Moander, I might, in my recollection was that if Cimerex had prevailed today, this case would have gone to the OCD, but that based on where we left things previously, we're now going to get, we would now have a de novo hearing at the OCC. I don't know if we just need to go back and review the order and perhaps the transcript from where we left off back in, maybe it was April. That might spare another round of motions.
One thing we could do, and I know that this may cause a little tooth grinding, is we could see the commission could set this matter for status conference next month, like 10 minutes. And that'll give all the parties time to take a look at everything. And then if there's a need for motion practice, the commission could assign that to a party and say, brief it, and we can proceed from there. Because I will recognize this case is big enough with enough details and enough hearings on it that I think everyone involved would benefit from a review. I do, just to make sure nothing is lingering here, because there's been a lot going on, a lot of moving parts, and I would be saddened if the commission missed an opportunity to address, say, a procedural issue that needs addressed.
Okay, Ms. Davidson, can we add this to the April docket for a quick status conference?
Yes, we can.
All right, thank you.
Thank you all.
All right. I think we are ready to move on to the remainder of the agenda. Agenda item number 6 was also continued to June 9th. And any updates on pending litigation, Mr. Moander?
Madam Chair, in case A-1-CA-39578, I am still awaiting action by the Court of Appeals. The only activity that's gone on is there was a substitution or a withdrawal of one attorney for one of the other co-defendants, but nothing substantive.
Thank you. Is there any other business in front of the commission today? All right, our next meeting is on April 14th, and it sounds like I will be seeing you again, Mr. Padilla and Savage. All right, thank you, everybody. Have a good rest of the afternoon. Is 2:30 on the 10th, and we will adjourn.
All right, thank you.
Thanks, everyone.